supplementary cause list, item number 1 for pronouncement of judgment.
So I'll read out only the operative portion. So Mr. Nongpyo writes, I think this court cannot come to your rescue to the fullest extent. The fact being, see, when there are no relevant rules, then how can you be promoted? There must be some basis. Rules have to be there upon which you will be promoted. And promotion is not a right. The right to be considered for promotion is there. So to that extent, you have a right to be considered for promotion. But if you are to be promoted, there has to be relevant rules.
In fact, these are sanction posts, Your Lordship.
There are sanction posts, but even sanction posts, there must be, you see, how would you occupy those posts without a proper, format, so to say. So what this court will do is, it will direct the respondent to bring out the relevant recruitment rules within a time frame of 3 months.
3 months.
And if anything after that, you can always come back to the court. I'll read out the operative portion. The petitioners herein having been denied to be considered for promotion for about 20 years or so, the grievances have to be addressed accordingly. On the authority of the case of FCI, this court coming to the conclusion that the petitioners have made out a case to be considered for promotion, accordingly the competent authority is hereby directed to bring out the relevant recruitment rules indicating the mode and manner wherewith the petitioner may be promoted to the next higher post. The exercise is directed to be completed preferably within a period of 3 months from the date of receipt of a certified copy of the judgment and order. Keeping in mind the fact that the petitioners have been deprived of their right to be considered for promotion for a considerable length of time, the authorities may look into this aspect while bringing out the relevant rules. The above, this petition is disposed of, no cause.
Lordship, I beg to mention item number 17, Lordship. I may be allowed to withdraw, Lordship.
So,
Yes, Lordship. I may be allowed to withdraw, Lordship.
Why?
Lordship, because Lordship, in similar matter, the relief was granted. So there is a change of circumstances. So this matter is connected with the other matter. So that's why, Lordship, I may be allowed to withdraw with liberty to file afresh, Lordship.
On prayer made by the petitioner, this matter is hereby dismissed as withdrawn.
With liberty, Lordship.
Liberty, it is always up to you. If you have a right, you have a right.
For the same cause of action, Lordship, actually, Lordship, in connected matter, it was WPC 114 of 16. It was disposed of in the month of April. So thereafter, there will be a change in my pay scale. So this matter is also connected with my pay scale, Lordship. So that is why, Lordship, if they do not take any action, or if they go in appeal and then appeal is lost, that's why, Lordship, I am praying that liberty may be granted, Lordship.
With liberty to file a fresh application under changed circumstances.
Okay.
Your Lordship,
Yes.
this item number 4, Your Lordship, doesn't part hard, Your Lordship.
I got a little objection in that because I was submitting my part.
Just a moment. What is, he has not even finished his submission.
Oh, yes.
Your Lordship,
He was just mentioning 4 and you have jumped the gun.
No, I have the objection I just said, Lordship.
Your Lordship,
Objection to his mentioning. He has not even concluded.
No, let him do, let him do.
Your Lordship, in this matters, when last question I was arguing the matters, and when I was referring this additional affidavit, and it was not found in the record, Your Lordship. So I discussed with my this
Additional affidavit? Whose additional affidavit?
my additional affidavit. This was not in the record of the court. So Your Lordship, this it is required to bring in my record. Even my synopsis of argument, I have referred these all matters. The similar to whatsoever I referred, this to bring before the honorable court for the additional documents.
So
There.
additional affidavit have been filed.
Your Lordship, it is not in the record, Your Lordship.
No, not record means you have not filed.
So Your Lordship, it was prepared everything, and how it is happened, it is my fault.
Then
Your
what
Lordship.
can we do at this,
So
at
Your
this
Lordship,
stage?
so Your Lordship, I may be allowed to file my additional.
How can you do that, Mr. Devnath? We are at the hearing stage.
So Your Lordship,
The hearing is already
even
almost
when I've
completed.
given my synopsis, so I referred everything, Your Lordship, on good
Yes.
faith.
So
So Your Lordship,
if it is not there, means not there.
so Your Lordship, I may be allowed to, Your Lordship, since I'll file the appropriate petition, Your Lordship, in this matter.
I don't think. See, it's a 2015 matter. We cannot just go on.
Your Lordship, it is most important, Your Lordship, these documents is required to be produced.
That is, he should be diligent enough. It is the duty, your duty to look into all aspects of the matter.
I may be allowed to file petition, Your Lordship, to.
No, Lordship, there is no.
What is your case, Mr. Devnath?
This is the regarding this my area of pay, Your Lordship.
Area of
And there is some objection, and out of this, it was under RTI. I have collected the documents, and it was how it is not coming, Your Lordship, and then it was unexpected, Your Lordship. It is 2019. It is not this recently I have given. It is 2019.
Your pay is to be paid by the managing committee.
Your Lordship.
So they have not paid you.
Yes, right. Your Lordship, you kindly allow me just to file bringing this, and if you could, I file the affidavit. And whatsoever I referred in this my synopsis of argument, these matters will come. Nothing add will be there, Your Lordship. I have given in my written submission, and
Mr. But one thing you have to see, we are in the mentioning hour. Mentioning hours only for adjournment, but you have already argued your matter.
yes,
Let the matter be called up.
Lordship, my submission was earlier that since I was
Just a moment, sir.
half of the matter.
Mr. Chaudhary, it will be called up.
Okay.
You can
But
make a
that
submission.
should go.
Lordship, I beg to mention items 16 and 19, Your Lordship.
Again, 2015 matter.
Lordship, can you have the matter next week?
If you go on like this, next week, then when will it end?
Lordship, for today I'm a little bit not well first. Can you have it next week, Your Lordship?
Let the matter be taken up positively.
Should be taken up positively. What if, you say that you are sick, then what can I do?
Lordship, I'll take up the matter next week positively.
Then counsel for the petitioner has submitted that the matter may be taken up on the next date, as she is not prepared for the hearing today. On preamble, list this matter up to 1 week.
Your Lordship, item 19 as well.
Here the petitioner was supposed to take some instruction. There was some defect in the prayer portion.
It's not defects, Your Lordship. We had changed our ground. We did not mention any of the.
okay.
It's regarding that matter where 32 posts were advertised.
Okay,
and
32 and that
Whether
54.
to withdraw or not.
54 they got appointed.
Okay.
So, Your Lordship, we couldn't contact the client in this matter, Your Lordship. Kindly have it.
Fine. On preamble petitioner, list this matter up to 1 week.
Highly obliged.
May it please your lordship, I'd like to mention item number 18.
Number
18.
for?
I pray for a week time, your
You are
lordship.
for?
Respondent number 6.
Who's for the petitioner? He's here. Have you got his consent?
Yes. I've informed the petitioner, but I don't know. They've not called back.
On pre-meet by the your respondent?
Number 6.
Respondent number 6. Matter is adjourned. List is after 1 week.
Minutes list, item number 2.
Yes.
Please, Lordship, this is the BSF matter, my lord. We have come against the order dated 15/5/23 at page 17, my lord. My lord, by this order, the learned judicial magistrate, on their application by the state, my lord, has directed to hand over the accused persons to police, my lord.
The order is at page?
It starts at page 17, my lord. The operative part, the lordship will find at page 18.
Yes.
The last paragraph, my lord, the operative part of the order.
Yes. Yes.
But the last paragraph, my lord. I'm reading at page 18. In view of the reply submitted by the Commandant 4th Battalion BSF dated 9/5/23, who has extended full cooperation into the matter, the court hereby directs the Commandant 4th Battalion BSF to hand over the accused persons, namely Momin Singh, Constable Sangel Singh so-and-so, and driver Kadam so-and-so, for the purpose of investigation on 16/5/2023. My lord, there are some legal implications in this, in handing over the accused persons, my lord. My lord, as far as the police investigation is concerned, my lord, the police has come and they recorded the statement of the accused persons. In fact, the gun which was used for firing, my lord, even that has been seized by the police, and we are fully cooperating. That is reflected in the order itself. Our only problem is against handing over the accused persons to police, my lord. And the reason being, my lord, there are concurrent jurisdictions conferred on the courts under CRPC and under the BSF Act, my lord. And if you hand over the accused person, that amounts to surrendering the jurisdiction by the BSF authorities, my lord. And that is our main grievance, my lord. As far as investigation is concerned, we have no problem.
Then can parallel investigation be made?
My lord, ultimately what happens, my lord, police can file a charge sheet in the criminal court, in the normal court, and then section 80 gives us the power, my lord, to claim the case from criminal court and try before the BSF court.
But how, you see, now how would the process of recording of statement under 161 or 164 happen? How would
161 they have already done, my lord.
What have you done?
Yeah. They have recorded the statements. They have not come to the statement.
Already taken the consent.
161, no. Well, statement has not been recorded.
Because you understand, see, fiscally,
Madam.
see, the IO has to, question the accused.
We will facilitate. Our case is that he can come,
okay.
or we can bring them to their place, to the police. He can record the statement if required, 164 statement, whatever. Our only problem is with handing over the accused persons.
The only question is the custody per se.
Custody of the accused persons, my lord. They are already
Physical
arrested.
custody.
They have already been arrested by us, my lord. They are in our custody now, since the date of incident. The whole purpose behind this, my lord, any offence, I'll take your lordship to the BSF Act. Under the BSF Act, normal IPC offences are all mentioned, my lord. Apart from that, there are certain offences under the BSF Act which otherwise under IPC are not offences, my lord. For example, not obeying the command of the higher authority, violating the standard operating procedure. So these are also criminal offences under the BSF Act, my lord. So when we will try these accused persons, we will also try not only for 302, my lord, we will also try for other offences at the same time, my lord. Because not obeying the command of the superior, or there are many other things, my lord, which are normally are not offences under the IPC. But under the BSF Act, for a BSF personnel, even these are offences, criminal offences, my lord. Now, my lord, on the last occasion, objection was raised with regard to the maintainability. So, if I don't know whether learned additional advocate general is pressing on maintainability.
Maintainability, my lord, plus locus standi, my lord. These two aspects.
So, my lord, what I was praying, today is a motion hearing only, my lord. If some kind of, if the matter can be heard on some other date, my lord. But if some kind of interim protection is given that this order is not to be, shall be kept on hold, maybe we can hear the matter next week sometime, my lord. Because what I see, your lordship have been hearing the arbitration matter for last 4 days continuously. It will take some time to argue the matter.
So you are very considerate of the court.
I'll oppose the prayer, my lord. There is no question of the question of interpretation will come when there is a prima facie case, my lord. Now, kindly see, my lord, who is the petitioner in this case? Union of India. How Union of India becomes aggrieved at this stage. Now, my learned friend said that if in case, my lord, 2 courts have parallel jurisdiction, then Section 80 BSF Act comes. The ball is in their court. Why they should come here with petition for setting aside that order? Let them take a decision on that, my lord. Now, my lord, the thing is that if lordship kindly comes to the order passed, which has been appended in this petition. Now, my lord, kindly come, my lord, to page 23. Oh, sorry, my lord, not page 23, my lord. Sorry. Where is that first order? Once again. My lord, annexure, my lord, page 25, my lord, that is annexure 4. Now, this is the order dated 8 May passed by Deputy Inspector General, my lord. Whether lordship got him, my lord.
Yes, yes.
Now, small order, my lord, if I may allow to this. Whereas on 5th May, my lord, if I read paragraph 3, that will be all right, but then if lordship desires, I can read the whole part.
You read whatever is relevant.
Okay. Whereas on 5th May 2023, at about 20 to 30 hours, number so and so of unit.
Read paragraph 3.
Paragraph 3, my lord. As the alleged offence is committed by number so and so, HCGD Monishing number so and so, CT Sangel Singh Tudu and number so and so, Kadam Kishore Baburao or while discharging their bona fide government duties, therefore considering the facts and circumstances of the case, I, the undersigned, being competent authority under Section 80 BSF Act 1968, decide that, my lord, kindly, my lord, these lines are important, my lord, that in case any charge sheet is filed, now, my lord, come to that, my lord.
Yes.
Against the above personnel before any competent court of law for their trial, the case be claimed from the criminal court for the trial of the above personnel by security force court, as the same is also essential in the interest of discipline in the force. I further direct so and so shall be retained in custody. Now, my lord, this comes in operation when charge sheet is filed. My lord, lordship comes to Section 80 also, my lord. Lordship will find, my lord, nothing has been reflected so far as the investigation is concerned, my lord.
What does Section 80 says?
My lord, Section 80, my lord. Choice between criminal court and security force court.
Choice is given to whom?
My lord, here the officer of the BSF, my concerned officer of the BSF, my lord, I'll just read it out, my lord. When a criminal court and a security force court have each jurisdiction in respect of an offence, it shall be in the discretion of the Director General or the Inspector General or the Deputy Inspector General, within whose command the accused person is serving, or such other person as may be prescribed, to decide before which court the proceeding shall be instituted, and if that officer decides that they shall be instituted before a security force court, to direct that the accused person shall be detained in force custody.
Okay, so he has exercised section 80 here.
My lord. Now here, my lord, if the lordship comes, my lord, lordship will say the order when the charge sheet is filed, the question of concerned trial will come, my lord. Now, if lordship, my lord, further proceeds to 81, my lord. Now, my lord, that is the precisely when, my lord, my learned friend, on the last occasion said the court below has passed an order without any jurisdiction, my lord. Now, section 81 will make it clear, my lord. Court was, now, power of criminal court to require delivery of offender. When a criminal court having jurisdiction is of opinion that proceeding shall be instituted before itself in respect of any alleged offence, it may by written notice require the officer referred to in section 80 at his option, either to deliver over the offender to the nearest magistrate to be proceeded against according to law, or to postpone proceeding pending a reference to the central government. In every such case, the said officer shall either deliver over the offender in compliance with the requisition, or shall forthwith refer the question as to the court before which the proceeding are to be instituted for the determination of central government, whose order upon such reference shall be final. Now, my lord, the ball lies with the central government.
Is there any question of sanction here?
No question of sanction. No, but then, my lord, when this order of handing over the offender comes, my lord, yes, and if they are of the opinion that they cannot comply,
so
with
they
that,
can go
should
to
refer to central
they
government.
go to the same court.
Now, no, my lord, this should be. It should be, my lord, refer to the central government, my lord.
No, they go either go before the
requisition has to be before the court before which the proceedings are to be instituted for the determination of central government. So they should go back to that court, my lord.
They should,
and for the determination of the. Now, the ultimate thing is that, my lord, the ball is in the court, will remain with the central government. How come Union of India becomes a petitioner in this case, my lord? Now, my lord, second thing is that, now, my lord, if the benefit of this legislation is to go, my lord, will it go to the union or to the person concerned? How union becomes petitioner here, my lord? Here, my lord, the cost title has been filed to the Union of India.
Union of India, not through BSF?
Through BSF. My lord, but this is Union of India, my lord.
No, who has filed the affidavit?
This is some concerned officer of BSF, my lord.
By the DIG, Deputy Inspector.
Was completed under section 80.
Now, my lord, passing the furthermore, my lord, the passing of order, my lord, cannot be, my lord, simply on the basis of the provisions contained in section 80, my lord. My lord, the mode and manner of passing, the factor to be considered is prescribed in the BSF rules, my lord. And the order passed has no reflection, the order which has been appended with these things, that there is non-compliance. My lord, I will be relying on the decision of the Apex Court with regard to that, my lord. It happened in Jammu and Kashmir, my lord.
So what do we do?
Now,
Lord,
second thing is that, my lord.
My lord, I was praying for.
Kindly, my lord. Just for a moment, my lord. Now, so far as.
But only thing is that that order stands in the way, my lord. There's only some status quo, something maintained till Monday also.
My lord, that is not required because, my lord, order requires compliance by the next, my lord, this of
16.5.
16.5. We have crossed that date. What interim order will support? If it is simple adjournment, then I will definitely not object, my lord.
Joginder Singh.
I think it can be heard on Monday or Tuesday.
That's no problem. I'm here.
Monday.
Notice we issued today.
They've already accepted
it. This can be disposed of, hard and disposed of. It's a matter of law, man. It's a legal issue.
Notice or not issued?
Is it required? It's not required. Notice or not?
Notice or not issued? Simply a notice issued and matter fixed on Monday for hearing.
Dr. N. Musika, lawyer at DSGI. Mr. B. Shaji, lawyer at AAG, has accepted notice on behalf of the state respondent, only one respondent. As such, no formal notice is required. As prayed for by the parties, by the petitioner. This is matter for hearing on Monday.
Well, also on the question of materiality, that should be kept in open. Have hearing should not mean the final hearing.
Yes, yes.
We consider.
It's not been admitted, only notice has been issued.
The question of materiality may be left out.
It is also submitted by the learned AG that the issue of maintainability may be heard at the outset. List accordingly.
You don't want me to read it. Right. Let me read it. Oblige. Yeah, but it is not taking note of the end.
This is
Yeah,
SRTT matter. Can be taken up at the end of the board, my lord.
Only one issue, my lord, that one of the petitioner I am informed, my lord, Mr. Sri G.P. Walang is no more. So the memo of appeal has to be amended, my lord, as per High Court rules, my lord.
When did he pass away?
Because I am informed by... so that's why my learned friend may check up and find out.
Maybe today, yesterday or so, if that is the case, I don't know. Because
tomorrow also,
I have not seen any obituary.
So in fact, that he's no more.
I'll find it out, my lord. The matter is taken up at the end of the board, my lord, only for this
Yes,
purpose.
let's try to find out. But if the AG has said so,
Well,
he has the
I
power
am
to.
informed by the officer, my lord.
He may have the power to kill somebody, but he will certainly not have the power to resurrect somebody.
End of
So,
the board.
at the end of the board.
Daily course list, item number 1.
Sure, I'll require further time to find my rejoinder.
My lord, I'm appearing only for this respondents. There are private respondents also here.
Mr. Nongklau is appearing.
On premier by the learned counsel for the petitioner, who has sought for time to file the rejoinder. Matter is adjourned. List is here for 2 weeks.
Lordship, I have a humble submission. Lordship, the petitioner is traveling from US to India. So he'll be in Shillong on the last week of June. So humbly pray if the matter may be fixed on 27.
My lord, let the matter become of a hearing. In the meantime, they can file a rejoinder in that case, my lord.
Because the petitioner will be in station, he has to sign the affidavit. So I humbly pray on
No,
27.
my lord, I'm not objecting to that. Let the matter can come in the hearing list. My lord, rejoinder can be filed in the, and then the matter can come in after 4 weeks. So let rejoinder be filed.
This is a
matter can come for hearing.
You see, hearing will only be after all the pleadings are completed.
Lordship.
It's just a question of formality.
Because, my lord, my friend is praying for a time which is also approximate to 4 weeks.
4 weeks, Lordship.
That's what, my lord. So in that meantime, they can accommodate it.
Circumstances are such that the
My lord,
petitioner is staying outside,
My lord,
outside the country. So that has to be considered. Otherwise, had it been a person from Shillong or
Lordship.
elsewhere,
I have no objection.
On 27, Lordship.
fine.
Item number 2.
The respondents are yet to file the counter.
I pray for 4 weeks' time, my lord, to file counter to the.
You're appearing for?
I'm appearing for the school, my lord. Yeah, please.
Is this Assam Rifles?
Assam Rifles, ERPS method.
Yeah.
But why have you? Okay.
This is
The Assam Rifle comes within the umbrella of Union of India.
Well, that is the issue. Item number 5
this is
to
different
5 to
new
9.
case, my lord.
5 to 9 are there for
Yes,
submission
fine.
of the written argument. And this is for
Yes,
7th
because
May.
that question of maintainability and all those things.
That's
That's,
it, that's
in the other-
Article 12 and now everything.
Yes.
You are appearing for all the respondents.
My lord. No, my lord, I'm appearing only for the school, my lord.
Oh, okay. Okay, so you are for 2, 3, 4, and 5.
My lord. 3, 4, 5, my lord.
3, 4, and 5.
Yes, my lord.
What about 2?
2, my lord, sir, he'll be
CHC was appearing from earlier.
So what is required here? Counter affidavit.
Counter.
Have you filed yours, Mr. Debnath?
I'll be filing it.
Mr. R. Debnath, letter CGC, has submitted that the counter affidavit on behalf of the respondent 1 and 2 respectively may be allowed to be filed within the next date fixed, for which some time is prayed for. Similarly, Mr. Zincon has also made a prayer for the counter affidavit to be filed within the next date fix. As prayed for, this is matter after 2 weeks.
Item number 3.
May it please your Lordship. Your Lordship, we have already filed our compromise date by way of an affidavit as directed by this Honorable Court.
Lordship, I'm yet to receive that affidavit, so if that matter may come up tomorrow or Monday, Your Lordship. So I'll go to the deed of compromise. And
who's appearing for the private respondent?
Private respondent. Sudeep, Sir Sudeep is to appear in this. In this case, the only limited issue is that section 188 is, there are 2 sections which has incorporated in the FIR. 448 has already been compounded.
Which are non-compoundable?
188 is not compoundable, but that is not maintainable because the FIR has been lodged by the private persons. That is barred under section 195. So now the party has entered into an agreement, nothing but this.
What is the subject matter?
Your Lordship, this the FIR has lodged by the respondent number 2 for the violations of miscase order passed in the miscase, Your Lordships. That is truly civil in nature. So for that they have lodged an FIR against the petitioner that the petitioner has violated the status court order passed in the miscase, Your Lordship. So the FIR has been lodged against her. Accordingly, the charge sheet has been filed. The charge sheet has filed under section 448 and 188. During the pendency of the matter, the parties have entered into a compromise. On the basis of compromise, section 448 has been compounded, Your Lordship. That if Your Lordships can kindly come to page 32, Your Lordship.
Page 32.
Page 32, the relevant paragraph says page 33, Your Lordship.
Yes.
That and by virtue of the provisions as laid down under section 321 CRPC, offence under section 448 IPC against the accused Sri so and so is then compounded, Your Lordship. So 188, the London High Court has no jurisdictions to.
So what does 188 says? 188. What does it say?
that is, Your Lordship, I think that 188 is stopping the officer from performing the official duty, if I'm not mistaken, if I remember correctly.
Disobedient to obey or
Yes.
order promulgated by
Disobedience to order duly promulgated by public servant, Your Lordships. So if Your Lordships can kindly come to 195 of CRPC.
CRPC. Yes.
Yeah, if I may allow to read, Your Lordship. Prosecution for contempt of lawful authority of public servants for offence against public justice and for offence relating to documents given in evidence. No court shall take cognizance of an offence punishable under section 172 to 188, both inclusive of the Indian Penal Code, of any abatement, number 2, of or attempt to commit such offence, or of any criminal conspiracy to commit such offence. Exceptions on the complaint in writing of the public servant concerned or of some other public servant to whom he is administratively subordinate. In sections on the administration.
Yes, what does this section say?
Your Lordships, I'll just take Your Lordships to the relevant. Of any, Your Lordships, if I continue, except on the complaint in writing of the public servant concerned or of some other public servant to whom he is administratively subordinate, Your Lordship.
You are reading.
I'm
which?
reading 195 subpara B, Your Lordship, subclause B, Your Lordship, where it says that the FIR can only be lodged by the subordinate officer, Your Lordships. Private individual cannot lodge an FIR for violations of Section 188, Your Lordship. So this FIR itself for Section 188 is not maintainable in this case, Your Lordship.
So it's the private respondent who has filed the FIR.
Yes.
Okay. For 188, you cannot file under 188.
Here, what happened is there was some status quo order passed by the court. Now, the respondent admittedly acted in violation of that status quo order. So it was incumbent on me to report to somebody. So I filed a FIR saying that.
Yes, but you can report, but it is not for you to take action under 188.
188 is not maintainable. That is why, my lord, we said we had already settled the issue. The only impediment that came before the court, the honorable court, was 188 was not compounded. Otherwise, my lord, the other sections have already been dropped based on our compromise. 188 could not be compounded, my lord. That is why the knowledge practitioner, my lord, said that it's not compoundable, so it's not within my reach.
But prima facie, there's no case under 188.
As it is, my lord, I have already submitted. The issue has already been resolved.
Heard Mr. Learned Counsel for the petitioner. Also heard Mr. Esthapa, Learned Counsel for the respondent. Your respondent?
Respondent number 2.
Sure, I heard Mr. H. Abraham, Learned G. appearing for respondent 1. Respondent 2. But look at your petition, Mr.
It has not been implemented.
Okay.
He was subsequently.
Subsequently,
you have
has been
amended.
Your Lordship.
The Learned Counsel for the petitioner has submitted that the respondent 2 had lodged an FIR before the. Where have you lodged the FIR? Where is the FIR?
FIR is Annexure 1, page 13, Your Lordship. It has been lodged before the Pasture Beat House.
Before the officer in charge, Pasture Beat House, Shillong. Apparently for an alleged violation of the order dated 17/8/2015 passed by the Learned Court of the Assistant to Deputy Commissioner Shillong in Miss Case number 104 under bracket T of 2015. arising out of title suit number 43T 2015. To this extent, the said FIR was registered, and accordingly what is the police station case?
PS case number
accordingly Sadar PS case number 186 under bracket 7 of 2016 under section 188 oblique 426 oblique 427 oblique 448 oblique 34 IPC was registered. On completion of investigation, a charge sheet was filed by the investigating officer, finding a prima facie case well founded against the petitioner herein under section 188 oblique 488 oblique 34 IPC. Why 34?
34 because two accused has been involved in this case.
So only one is here.
I'm representing only one, yes, Your Lordship.
Then how do we drop the proceedings then?
So otherwise, before the trial court, both of them were present.
Whatever the case may be.
Yes. The other accused
Now we are on the proceedings as a whole.
Correct.
Section 188 not being attracted, so to say. But you have come, only one of you have come.
I'm representing only one.
34.
I'm representing only one accused. That's true, Your Lordship. The other accused.
If you are to be let off,
Your Lordship,
it should not be in this manner. It has to be only, after charges are considered or before charges are framed. And for that, you see, the High Court cannot take recourse to 482. You have not mentioned here that there are two accused.
It has never mentioned, never stated, Your Lordship.
Mr. Roy, what do you do?
That Annexure 3, page 28, there are two accused. Annexure 3, page 28, Your Lordship. Accused person Sri Jogendra Rai and Srimati Radha Rai are present with their respective counsels.
So how is the other accused related to you? Are you related?
No, Your Lordship.
How is he connected to this case?
That the allegation is that both of them, they had violated the miscase.
Yes, so whether collectively or individually?
The FIR is collectively, Your Lordship.
So you must have had a connection with him. You do one thing. You just examine this point and see if you can make out a case where any effective order can be passed as against in your favor without disturbing the proceedings or without giving any relief to the other accused if he has not come before this court.
Your Lordship.
1 week?
Your Lordship.
From now to 2 weeks on premier by petitioner. Recess matter to 2 weeks. You examine that. Otherwise, you may have a case, but then what relief can be given to you?
Item number 4.
So, Mr. Devnath, at this juncture, you said that you wanted to file an additional affidavit now.
Your Lordship, just whatsoever I have written in my this event synopsis also, it will not be changed.
Forget about that. That has no meaning.
Your Lordship, because of it, Your Lordship, it has been done, and copy is with me that it has been done. But how it is not in the record has come up, Your Lordship, it is not understood, Your Lordship. So there may be some mistake from my part, Your Lordship. So if you kindly consider, Your Lordship, it will be going to aspect my own, Your Lordship. And somewhere some mistakes is there, Your Lordship. I should apologize for it. Because when I prepared synopsis also, I referred everything. Because
I'll give you 1 week. You think about it.
1 week, Your Lordship, I will file.
Otherwise, if you feel that you cannot make out a case, then we'll hear the matter.
Your Lordship, by 1 week I will file, Your Lordship.
1 week.
The same matters whatsoever I referred in my synopsis argument, it will be remain same, Your Lordship. There will be no change.
On premier petitioner, this is matter to 1 week.
Item number 5.
My lord, I have filed my written argument, my lord.
But we are also ready for submission of this written argument.
Yes.
I just point out the order passed by this court on 28/4/2023. Lordship allow all of us to file the written argument.
Yes.
In the meantime, directed my friend to take instruction in regard to where they have given undertaking in the earlier case.
My lord,
the service condition will not be changed.
That is
So
not
only
the
that
subject matter in this case, my lord. My lord, that was a case relating to closure of the school. The notice was given by the school authority to close down the school because after implementation of the 6
Yes.
CPC.
So that was, but
That
then
was different
in that case, the only issue, one of the issues decided was the Article 12 matter.
In that case, my lord, what has happened is after the matter went to the Supreme Court, and thereafter, my lord, the school authority, they had to implement the 6 CPC, and they had to pay the salaries, arrears. And thereafter, my lord, the school had a financial constraint, and thereafter they have given a notice to close down the school. And to challenge that order, my lord, they have come before this honorable court under by WPC 100. And in that case, my lord, one affidavit was given by the Assam Rifle Welfare Education Society. By the Assam Rifle Welfare Education Society, whereas, my lord, here the petitioners, they are challenging the amalgamation of ARPS with RWS. They cannot, my lord, blow both hot and cold at the same time. From one side they are challenging the RWS, other side they are trying to rely on the affidavit which was given in that earlier case, my lord, in WPC 100. And that too, my lord, that was just a mere affidavit. That is not a direction or order of this court.
Anyway, whatever the case,
ultimately, my lord,
Mr. Sankon, whatever the case may be, see, the facts and circumstances of this case will stand on its own.
My lord.
Number one.
Right.
Number two, if any of the party chooses to rely on any authority beyond the pleadings herein, they are always welcome. So if that is the order passed in that case is also relevant here.
No, my lord, that is not relevant because ultimately
that is your stand. That would be their counter stand.
Ultimately, what had happened about that case is, my lord, the matter was withdrawn, my lord, and there was no such direction from this court.
I think I may just brief it. My friend is yet to aware of that fact. After Supreme Court decided all the issues, including the writ jurisdiction matter, they came here, implemented 6 CPC. And they say there was a financial crunch, therefore we want to shut down the school. So for the petitioners and other approach before this court, and during that pendency, there was a negotiation between the writ petitioners and the management. And there was a compromise they reached. So from the writ petitioner's side also, there was a concession with regard to some demands, some benefits. And they also came forward that we will withdraw the shutting down the school order. Now there they filed an affidavit that the service conditions of the petitioners will not be altered, changed by the management. So on that basis, the writ petition also closed already. Now what happened? In this case, after the matter was closed, after 9 months of that undertaking recorded by this honorable court, part of this order of this honorable court, they did this amalgamation process and introduced the new service conditions. Therefore, my limited prayer to that context is that undertaking was given by them, by the ROEs before this court, that service condition will not be changed. Now, after 8 months, they, in the form of amalgamation of these societies, they introduced new service conditions. So therefore, these two new service conditions, including transfer and, for example, the yearly suitability test, that ultimately affects or violates the undertaking given by them. To that extent only, therefore, Lordship has directed him that if you want to take latest instruction, you take it. If my friend said there is no need for instruction, no problem. No problem.
If I
Lordship
can,
will decide this matter.
If my lord, I can clarify. My lord, as far as those undertakings are concerned, that is as relating to the, that was relating to the 6 CPC, my lord. Now here we are not.
Actually, you see, Mr. Sinkon, if I can understand correctly, what Mr. Sangresu has submitted is that in that list, the respondent, rather the ARPS or ROS, whoever the authority is concerned, has given an undertaking that let the matter be decided, let the matter be be closed.
It was not our submission.
Let's perhaps I don't know. The wordings may not be such, but it would be in the lines that this is the undertaking given that the teachers there will be no transfer of.
No, there was no question of transfer in that case, my lord. That was only relating to the 6 CPC, my lord. Okay. And that undertaking also, it was not an undertaking, it was an affidavit which was given, my lord. That is not enforceable, my lord.
Oh, my bad.
That is not enforceable because that is not an order of this court, not a direction of this court, my lord. How can that be enforced in this proceeding, my lord? And moreover, my lord, the proceeding which is involved in this case is relating to the transfer and amalgamation, my lord.
See, Mr. Sukon, if even if you have filed an affidavit or otherwise, if the court has taken cognizance of it, then that is
right. Exactly. It's part of the record. It's part of the record.
That matter was not disposed on the ground of that undertaking, on the basis of that affidavit, my lord. It was disposed on the basis that there was a settlement between the parties. Only on that basis, my lord. My lord, I have already filed my written argument. I do not have any.
Yeah, you have highlighted this fact.
My lord, everything I have highlighted there.
Mr. Sangresu, you have
we also submitting the two submissions, 2 papers. I think we can exchange each other also.
You have filed yours. Why? Everything's ready just for judgment to be reserved.
Yes.
Reserved?
No. Yeah, that I will never do until and unless everything is complete. Then the judgment will be reserved.
And the matter will be listed on Monday or Tuesday.
I'll give you till Wednesday. Monday, Tuesday, I think.
Yes.
Mr. H.L. Sangresu, Learned Senior Counsel, appearing for the petitioner, has submitted that the written synopsis of the written argument has been filed before this court. And synopsis of the argument has been filed for this court. As far as the petitioners are concerned. Similarly, Mr. Sinkon, Learned Counsel, appearing for the respondent. Your respondent?
I am for the school authority. Different respondent in different cases.
Respondent ARPS.
Yes.
Has also submitted that the written argument on their behalf have also been filed. Mr. K.P. Bhattacharya, Learned GA, appearing for the state respondent, has however sought time to file the said written argument. Are you filing yours, Mr. Devnath?
No need to file my
Mr. R. Devnath, CGC, appearing for the Union of India, has, however, submitted that no written argument will be filed on his part. On the submission made, the state respondent is directed to file the written argument within the next date fix. This matter on Wednesday will be, where is May? 31st.
Yes.
Item number 10.
Lordship, in this case, I need some time, Your Lordship. Because,
Mr. Nongri,
this matter,
you are supposed to get instruction.
I've spoken to the officials of the MECL. They're filing the compounding by next week, Lordship. Everything is ready, signatures, because the compounding, the offences of 14, 15, 15, 16, 16, 17, 18, 19, all the years. So all the signatures of all those past CMDs also are required. So it took some time.
How long?
Everything is ready. They're filing it next week.
Next week.
That is the instructions I've received.
let it come after 3 weeks, Your Lordship. Because I got the instruction that...
Because you see, after, but the matter is stayed, you see. So should I release the stay?
No, it will not with Your Lordship. Because
you see, Mr. Nombri, you will file your petition before the trial court.
Yes.
The court will consider your petition and pass necessary orders.
But Your Lordship, I'm here for the financial year of 13-14.
Okay. Oh, okay, 13-14. So, okay,
Yes.
so that has got nothing to do with it.
That's nothing has to do. Now they've come with a plea that there is a typographical
As far
error
as
on their
13-14 is
part.
what?
It should be 14-15.
Then why are we?
They should have withdrawn the complaint case then.
See, Your Lordship, here I got the intimation from the ROC that for the company secretary, he has asked for 1 week's time. And by this time, he will be filing this. And after this, experience matters will come up.
I also have this mail.
So, Your Lordship, let it come after 3 weeks, Your Lordship. And if within 1 week it is done, and after this,
Once they file for the financial year of 14, 15, 16, 17, then the 13, 14 may be quashed or direct them to withdraw the complaint.
Your Lordship, after having this company application, then adjudication order will come up. Then automatically you will be submitted before this court. That's where we are doing the case. So when it is on the process, you let it come after 3 weeks. Your Lordship.
Because I'm here before financial year of 13-14 because section 148 was not enforceable at that relevant point of time.
Parties have submitted that this matter may be adjourned for the day to allow the parties to seek, to allow the council to seek instruction and to take necessary steps before appropriate forums, so as to enable this court to come to so as to enable the parties to submit before this court as to how the proceedings are to proceed. Since I'll not mention that. That is up to you how you file your compounding. If it is not subject matter of this petition, then it's not.
Yes.
Or premiered by the parties. This is matter of the 3 weeks.
But
be decisive.
10 to 15.
It's a 21 matter. We are lingering on a point when apparently you have no case.
Item number 20.
Please, Your Lordship, for this matter we have done everything. We already filed written argument.
Your file?
Yes, Your Lordship. So kindly reserve it for judgment, Your Lordship.
Your file, yours?
We have filed.
Then counsel of the parties have submitted that the written argument have been filed. Accordingly, matter is now posted for judgment.
Item number 21.
Also in this case,
yes,
we have challenged the orders passed by the trial court as well as the appellate court. In 2011, the
yes, Mr. Lindo, how long will it take?
It takes some time.
Should we continue after lunch?
The only problem is that due to the death of Mr. Herman, we have a condolence meeting in the district council also.
Let it become any other date. So next date?
Because it will take some time, because it involves substantive questions of law.
Yes. So tell me.
Any date, your lordship, as per the command.
Next week also is very 2 weeks.
On pre-made by the parties, let's this matter to 2 weeks.
Deeply obliged.
May I please, your lordship, I pray for a week's time to file the written submission.
You are for?
Respondent 2 and 3.
2 and 3. Have you filed yours?
Filing it. I'll be filing it now, your lordship. Actually, this matter is respondent number 5, the state respondent will tender their argument.
Oh.
My lord, what has happened?
Oh yes, last time you were sick.
Yes, my lord, I was sick.
So you are still sick?
No, I am recovering out of it, my lord. What has happened, my lord? Since the filing of this case, my lord, all along there was no representation on behalf of the register of
Sub-register or register.
Whatever. So what happened thereafter, upon being noticed, then we entered appearance. But then we don't have any of the copies of the pleadings which the parties, only certain bits and pieces, my lord. On the basis of which, no, my lord, that is very unfair on their part to expect us that we will have to, because they were also made party in the lower court, and they expect that in the high court the same lawyers should have come and continue the case, because it's a continuation of the same case. But the fact remains is that the deputy commissioner's office was represented by some other government lawyer in the lower court. So, and the petitioners and
No, see, Mr. Sengupta, have you got a copy of the petition or not?
No, my lord, not complete, my lord.
So?
Only some bits and pieces, my lord. We cannot make any.
So what do you require now? Tell me.
My lord, in fact, my lord, if they give us the complete petition, my lord, then only we can ask for some comments from the deputy commissioner's office, my lord. Otherwise, on the basis of verbal instruction, we will not find anything from any. At least we have to give them a copy. This, which was very much.
You have served a copy, your lordship.
You have served
a copy, my lord, like this, my lord, without annexures.
Subsequently, we have given the annexures.
They have given us this one, my lord. How we make sense out of it, my lord? And
Just
we
check
are
for the
asked to
notice.
give a detailed reply on it. Of course, my lord, our stand is very limited, my lord. What has happened? Some parties have come forward for registration, and the sub-registrar has declined registration on the ground that saying that there are some complaints, my lord. So in that view of the matter, the sub-registrar says that I cannot be the authority to decide right, title, and interest. You go to the civil court. So according to that, it is awaiting the verdict of the civil court. So sub-registrar will have very limited role to say on that. We cannot determine who will be the actual owner, or should we register or should we not register. We have, the moment there is a complaint, we said we are not entering into the merits of the case. You go and decide your title.
We still have to look at the provisions of the Registration Act.
Correct, my lord.
As to whether you are bound to register or not.
We are bound, my lord, only on the direction of the court. Should they come with a clear title, my lord, we'll do it. Otherwise, my lord, if we are to decide it, my lord, then there will be nothing left for the civil court to decide.
Anyway, we'll look into it. You give him
a notice whereby they have received a copy, lordship, dated 16/6/2022.
Received by?
No, but it does not
Because
indicate,
what
my lord.
happened, Your Lordship?
The office must have
Copy of the petition, my lord. Copy of the
Initially, we
petition.
served them a copy.
No, the office must have received it. You are.
I'll verify, my lord. But our limited stand is we are very clear about our stand, my lord. We are not so much dependent on their documents what they are giving to us. There must be records in the
Because
or
it's
in the
true,
sub
true.
registrar's office. But the fact of the matter is that it was not fair on the part of both the parties not giving us the document and expecting us to give a fair submission before the court. So we were mute spectators saying that it is the dispute between the private parties. Let them settle whatever with the revision verdict. We will follow by the verdict of the court.
It is. You are the principal. Let's put it this way. Principal factor in this whole affair. By failing to register, you have created a grievance.
Because of the complaint, my lord.
Exactly, because so that you have to explain that stand.
The person who has objected, they must be there in the party. So if they cannot satisfy, my lord, it is not for us. We are not at loss. We can very well next day can give our instruction that there is no objection. You register it. They register it. Someone will be agreed.
Exactly. So your stand has to be explained.
Yes, my lord.
So for that you will require all these.
No, we don't require actually, but it would have been fair on their part, on the part of both the parties to provide us the copies. And if they expect us that we will go here and
Fine. Whatever is required, then you give them an extra copy.
We'll do that, Your Lordship.
So
let them compile it. And because the other day there was a lengthy hearing, my lord, I did not want to interfere in any manner to cause hindrance of the hearing, my lord. But then when asked to us, my lord, because we know our limitations, my lord, so we were mute spectator. We were saying whatever is the verdict of the court, we'll communicate to the office and we will comply with.
Mr. S. Sengupta, Leonard Senior, Additional Senior G, has submitted that the respondent, your respondent?
Respondent number 5, my lord.
Respondent 5 was not in receipt of the complete sets of
the
pleadings for which the so as to enable the letter counsel to
pursue the matter.
State its stand before this court. It is noticed that this matter has been heard as far as the petitioner and the respondent, the other respondents are concerned. However, to be fair to the parties, as agreed to by the petitioner, the petitioner is to submit an additional set of all the relevant papers to the respondent 5, whereupon on the next date fixed the matter would be the respondent 5 will be heard. So how long?
It depends on them, my lord. Thereafter
We'll hear you and the matter will be closed.
Our stand will be very limited. Whatever be the verdict of the Honorable Court, we'll have to follow.
So how long? 1 week?
Which time will do, Lordship?
Your Lordship, if a copy of the written submission be supplied to us.
Just for reference, we'll supply, Your Lordship, but this is just for the courts to refer it. Verbal submission has been concluded.
Fine.
If they want a copy, if they insist for a copy, we'll give it, Your Lordship, no issue.
This is matter after 2 weeks.
Obliged, Your Lordship.
Obliged, Your Lordship.
Second report from supplementary cost list, item number 3.
Have you confirmed?
Yes, my lord. On Google also I searched, I found.
Google.
My friend has shown me on Google also.
I don't know.
There was a condolence. I think my learned friend Mr. Osaka also.
So when did he pass away?
23rd of February.
Oh, 23rd February.
Yes.
So the memo party will be required to be amended.
So, my lord, petitioner number 3, my lord, can be struck out.
So then the rule says that they will have to file the amended memo parties under Rule 25 of the High Court rules.
We'll do that today.
So then matter will come up for tomorrow because on behalf of dead person, petition can't be argued.
Yes. He has been made. He is also a respondent.
No, read petitioner. He is a petitioner. Petitioner number 3, Your Lordship may kindly see page.
Yes, petitioner number 2.
But D2 to बस करके खत्म कर देंगे साथ में D2 to group करके खत्म कर देंगे.
Dr. N. Musica, Senior Counsel, appearing for the petitioners. It has been submitted at the bar that the petitioner number 3, Shri G.P. Walang, has since expired. The Senior Counsel has therefore submitted that the petitioner, the remaining petitioner may be allowed to file an appropriate application in this regard.
Well, my humble submission, it can be struck out by
the rule says that they have to file amended
memo part
with the small application, because that fact has to be judicially recorded.
You require instruction on that?
My lord.
You require instructions on that?
No, my lord. I confirm from them that he passed on.
The Learned Senior Counsel has therefore submitted that the name of the said petitioner number 3 be struck off from these proceedings. The said submission not being opposed by the respondents, the prayer is allowed. Accordingly, the name of the petitioner number 2 is struck off from these three. Number 2 is still there?
Yes.
Okay, please. I'll be very sure, otherwise next day.
And 1 is also not there, my lord. Our case is 1 is also not trustee of the trust.
He's alive. He's alive.
He's alive, I know. God forbid.
You're referring to rule?
Rule 25 of High Court rules. At page 25, my lord. Page 25. 28. Your lordship will find at page 28 on death of a party, my lord. An application supported by an affidavit shall be filed for an order amendment of memorandum of appeal consequent on the death of party, including parties whose heirs are already on record.
Does this apply to repeating?
It applies to page 28, Rule 25, my lord. This will, though it is worded appeal, my lord, but this is the rule which applies to writ also, my lord. Because amended memo is required to be filed. And when we challenge the order also, the order will say, because in the correct memorandum of appeal is required, correct memo parties are required, my lord, because it is a judicial record. The High Court being court of record, the records are to be as per the law and as per the parties which are before your lordship.
So, Dr. Musica, you go through this rule and see if it is applicable.
Support and evidence shall be filed.
Then you have
for an
to
order of amendment of the consequent of the death of party, including a party whose heirs are put it in the report.
So you have to file an application.
I'll file an
then?
application.
Yeah,
Might
because
come tomorrow.
that'll
This
be
is sort of one line order is
One
required.
line
After that, the matter can be heard.
Just a procedural.
The procedural order is required. That's all. Procedural order. I am here now. I am ready to cooperate in hearing in whatever way and whatever manner. We have also filed a contempt petition which will be coming up in this matter only, my lord. Your lordship has restrained the trustees from alienating the piece of land of the trust. And despite the order of your lordship, the land has been alienated. What we have found is very disturbing. What we have found is very disturbing that they have opened a separate bank account in the name of trustees of SRGT, my lord. And the third disturbing factor which we have noticed, my lord, is that the trust is a public trust which is meant for, and trust deed clearly says that the entire facilities are for the inhabitant of Shillong. It is not a private trust where trustees can use the money for the purposes of their own benefit. So there are some issues. We have filed the contempt. That contempt will also come up for hearing tomorrow along with this matter. We have already filed it because we have placed that also.
And on pre-made by the senior counsel appearing for the petitioner, this is matter tomorrow.
Obliging.